I just want to introduce the moderator and chair. He wasn't here when I called out the people who were on our program committee, but Avi Cover, who is the Associate Dean for Academic Affairs at the law school, is also our director of our Institute for Global Security, Law, and Policy. And Amos Sciorra, one of our speakers today, was the inaugural director of that. And I'm sure he would be very proud to see all the things that Avi has done in all the years since Amos left to go to Utah. While I was dean, we didn't have a vice dean, but that role really was the one that Avi played. And the successes that the law school had for the last several years are due to Avi and other colleagues. So thank you, Avi, for organizing this panel and chairing it, and I look forward to it.
Thank you very much, Michael. So in 1947, the designers for the headquarters in New York called for a complex accommodating 70 nations. As Cal Rostiala writes in his account of the life of Ralph Bunche and his role in the UN, with the advent of decolonization, the UN was too small almost from the moment it opened. Now, 75 years out from their ratification of the Geneva Conventions, we may similarly ask, is there enough room in these treaties to accommodate, amongst many items to be discussed today, the pivotal group of non-state actors? Now, to be sure, efforts have been made to adjust. We can look at Additional Protocol 1, which extends jus in bello to armed conflicts in which peoples are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. It's generally accepted that Common Article 3 applies to such groups. And on the other hand, there are concerns that the inclusion of such groups validates or legitimates them. But as one of our panelists, Ezekiel Hefes, writes in his introduction to his recent book, there are now, as of 2021, around 600 groups active around the world with the capacity to cause violence of humanitarian concern. And he writes further, about 100 million people are to be found living in the territories under armed groups' control or influence. Between 50 and 60 million live in territories where armed groups exercise state-like governance. So, as with the other groups, I imagine we will be wrestling with, do the conventions need to change? Can they be adapted? And we are fortunate to have 4 wonderful panelists to tackle these varied and complex issues. I should note, I am abbreviating each of their very extensive biographies just so we can get to the substance of their work. Dr. Ezekiel Hefes is the director of Watchlist on Children and Armed Conflict in New York. Prior to joining Watchlist, Ezekiel worked for Geneva Call as a senior policy and legal advisor, and for the ICRC in various operational positions in Colombia, Afghanistan, and the Democratic Republic of the Congo. He's written extensively on non-state actors and international humanitarian law, most recently publishing a co-edited book with Catherine Fortin titled Armed Groups and International Law in the Shadowland of Legality and Illegality. Next, we have Sandy Hodgkinson, who is now the Senior Vice President for Strategy and Corporate Development at Leonardo DRS. Sandy previously served as a civil servant in the U.S. government, achieving the rank of Senior Executive Service with assignments at Department of Defense, State Department, and the White House. Her positions have included, and this is not an exhaustive list, Special Assistant Chief of Staff to the Deputy Secretary of Defense, Deputy Assistant Secretary of Defense, Deputy to the Ambassador at Large for War Crimes Issues. A widely published author of many scholarly articles, she also spent 6 years in the U.S. Navy Judge Advocates General Corps with tours as an appellate clerk at the Navy Marine Corps Court of Criminal Appeals. She has served as a prosecutor, and she's trained foreign military and civilians in over 30 countries. Dr. Amos Sciorra is a professor at the S.J. Quinney College of Law, the University of Utah. He is a distinguished fellow at the Consortium for the Research and Study of Holocaust and the Law at Chicago-Kent College of Law, and a distinguished fellow and counselor at the International Center for Conflict Resolution Katz School of Business, University of Pittsburgh. He previously graduated from and taught at this law school here and held the position of director of the Institute for Global Security Law and Policy, as Michael mentioned, and he served in the Israeli Defense Forces in several capacities, including as a legal advisor. His recent scholarship has focused on the question of bystanders, originally in the Holocaust, and enablers, resulting in his previous books, The Crime of Complicity, The Bystander in the Holocaust, Armies of Enablers, Survivor Stories of Complicity and Betrayal in Sexual Assaults, and The Complicity of Silence, Confronting Ecosystems of Child Sexual Abuse in Schools. His forthcoming book, Enablers Through the Ages, Normalizing the Unimaginable, focuses on enablers in the Holocaust and in Israel. Finally, Professor Gabor Rona, where he's a professor of practice at Cardozo Law School. He served in significant positions relating to international humanitarian law and human rights law, often focusing on their application in the context of counterterrorism policies and practices. He served as the International Legal Director of Human Rights First, where, fortunately, I was able to learn much from him when I worked as a colleague with him some 20 years ago. He also has served as a legal advisor in the legal division of the ICRC in Geneva and represented the ICRC in connection with the establishment of international and other criminal tribunals, including the ICC. He's taught at the International Institute of Human Rights in Strasbourg, France, the University Center for International Humanitarian Law in Geneva, and Columbia Law School in New York. So we will hear from all four panelists in succession. Then we'll engage in a little bit of a colloquy, posing questions to one another, and then we'll open it up to the audience. So first, we're very fortunate to hear from Sandy.
Thank you. I'm really excited to be here. I had fun yesterday at the panel of experts that we had, this group, and I'm really delighted to be able to talk with this group today here about some of these issues that I find are really important. So, I want to pick up where we left off because one of your brilliant law editors raised a great question, which is this whole, is it the right time or is it not the right time? And I do think that I have several thoughts on it, but it brings me back to the discussion of it may not be a one-size-fits-all. We're going to have 4 different panels, and we're going to talk about different aspects of the law and whether the existing law can be translated and disseminated down to a level that ultimately gets trained and indoctrinated and can be held accountable by the military. And I think it's different in each of these categories to some degree. And in our panel is an area I think that it's not as clear what the law is. So we go back to what is the right time and who are the right stakeholders to take on this effort. And I think it does start in a room like this with a group of experts. I mean, we heard about Tallinn and what that has done for the development and understanding of cyber law. I think it has done a lot to have practitioners and lawyers really try to figure out what is it that we know and what is it we don't know, and how do we get that guidance out there, and how do we use it in our training materials to refer, military officers who are writing doctrine to the Tallinn Manual, to 1, 2, and upcoming 3. So I think that you can do a lot without necessarily a treaty. That said, I do agree with the point that, waiting for there to be mass devastation at the end of a conflict that goes horribly wrong is a tough time to want to pick up the pieces and start over. So if there are areas where an additional protocol or statements that are agreed to by multiple states could fill gaps, then I wouldn't be too shy to press people in this room to consider attacking it and doing it, because it is hard. I struggled, in my own years and continue to with the U.S. government's position on whether or not you could update the AUMF. Right? We had an AUMF that I think every expert recognized was temporally frozen in the wrong time. But there was a fear that if we opened it up, then it could be worse. And that fear isn't going to go away, right? So responsible stakeholders, whether, and those include the ICRC, they include state governments, they include practitioners, and they include academics, all need to kind of find these rooms where they can come together and accept that in some areas we can translate what we have, and in some areas there just might be some gaps. And in this particular panel, That's, I think, one of those areas. As we look around right now, there are multiple conflicts unfolding where some clarification, I believe needs to be made. Particularly if you take a look at some of the issues that have come out post 9/11, right? That could have been that seminal moment to try and put out new rules on who the combatants were and what the character of the conflict was. There was massive disagreement. And I think, very much to the credit of the U.S. government and other governments, and I know John Bellinger will talk about this. I mean, he personally led a strong effort to get European governments and the ICRC and others to agree to what status individuals had. And if you weren't in the Geneva Conventions as a POW, there was this assumption you were necessarily a civilian. So you had this whole group of people that were out there that were engaging in conflict that were clearly not POWs. It wasn't that the Geneva Conventions were being ignored or being thrown out. It was that you looked down this extremely prescripted convention and you couldn't find the people that were in there. They if you applied it perfectly, they actually didn't have the status that they were taking on. So it wasn't that the Geneva Conventions were being thrown out or not applied. It was that they were being applied so word for word that individuals were not afforded POW status because they forfeited that right by actions they took and that were not consistent with the conventions. And so there was, a sense that they were being ignored or thrown out when, in fact, in reality, they were being read and respected. But at the end of the day, the decisions that the governments took at that time, not everybody agreed with. And so there was massive disagreement. And it took, I want to say, multiple years to get any other nations to really stand behind the U.S. government and say the words that you can actually lawfully detain someone who isn't a POW and not consider them just a civilian, right? And so getting from what was once upon a time called the unlawful enemy combatant to the unprivileged belligerent to the belligerent who doesn't have full status and all the different things they've been called in this evolution, I think it is an example of where state practice actually brought us along. And so I think you can do a lot with that. But it isn't where you want to leave that person on the battlefield, because we had a lot of military members who were reading in the press that they were unlawfully detaining people, that they were war criminals, that they were not following set standards. And I think that's not where we want to leave the youngest person. It's not where we want the military to be, because they can brilliantly train in the way that we heard today from Jim Johnson and brilliantly implement policies that are clear enough. So just real quickly to lay out areas I think that you need more clarity. I think for sure in NIAC right now, we need more clarity on status, specific treatment standards that are afforded upon capture. I think the status of combatants themselves is not entirely clear. I think there are disagreements within this room on personnel and status treatments. I think the duration of detention is not entirely clear because it's extremely complicated to determine the end of hostilities in a non-state actor world where it isn't a state that can actually say we surrender, right? And it's hard to enforce that. So the end of hostilities is unclear. And I think it leads itself to targeting issues that are very unclear, because all of this is that when the targeting attaches in particular to individuals whose status is not clear, it is very difficult to make those targeting decisions. They're complex. We have all the people in place to make them, but the rules aren't necessarily clear. And the last thing I just want to say is, with that lack of clarity, we do have the role of that the media is playing in it. And as I was listening to the last panel on AI, the importance of verification of data, it really comes into play in how these conflicts are being perceived. Because right now, you can read the headlines of any major newspaper and have, I think, a very different view of what is happening in detention and targeting decisions in the Middle East and elsewhere, just because you're reading headlines. And the data that may be being presented isn't necessarily the data that's factually accurate, or it's certainly not all the facts. And as a result, you again end up with the service members who are on the ground reading about acts and legal statements and pronouncements about what they're doing that may or may not be true, and is also inflaming the conflict. again, the end goal here is to minimize human suffering and to protect civilians and protect innocents. And so having a rational understanding of what's happening in the conflict is helpful. And I think laws and clarity get us closer. So I'm a huge advocate for what Michael is proposing here, for what this group is and can do. And I would simply just empower you to the extent you can within your organizations to look at a really constructive way to dialogue on particularly this NIAC detention and targeting area and see what areas we could get more clarity on and what tools can we possibly bring to bear for that. Because I think there are multiple tools that can be used that are short of treaty. But not to rule out ultimately an additional protocol or a statement of interested countries, et cetera. So I leave it at that for now.
Sandy, thank you so much. I think that tees up some good issues for us and probably leads well into Gabor, your comments.
Thank you, Avi. I want to address two categories in non-international armed conflict and non-state actors. The first being the combined topic of mercenaries and private military and security contractors. The second topic flowing from Sandy's comments about that relate specifically to detention in non-international armed conflict. And forgive me, I'm going to pretty much read because it's dense and I just want to get through everything. So neither the Geneva Conventions nor the additional protocols mention private military security contractors. The Geneva Conventions don't mention mercenaries. The second additional protocol doesn't mention mercenaries. The only mention of mercenaries is in additional protocol 1, Article 47, but only for the purpose of denying them combat status and prisoner of war status upon capture. And that confuses things rather than clarifies, because it doesn't tell us what status these individuals have under IHL. The problem being that the default status in IHL, well, if you're not a combatant, you're a civilian. But again, following up on Sandy's observations, it is highly improbable that parties to armed conflict will apply civilian status and protections to enemy mercenaries and private military contractors. Now, there are two international treaties that deal with mercenarism: 1989 International Convention on the Recruitment, Use, Financing, and Training of Mercenaries, and the Convention for the Elimination of Mercenarism in Africa, adopted by the OAU in 1977. These treaties are both, I would say, obsolete because there's such a narrow definition of the term mercenary, and also there are very few state parties to either of these conventions. It's a common observation that I learned at the ICRC that if you happen to have, the misfortune of being convicted of mercenarism, it means that you had a pretty lousy lawyer. Anyway, a mercenary is a person who participates in hostilities in armed conflict, is not a member of the armed forces of a national or a national of a state for whom they fight, and fights primarily for money, not for the love of the cause. Thus, for example, and Wagner Group is on our minds a lot, but the majority of the members of the Wagner Group will not be mercenaries because they are Russian nationals, at least in the conflict in Ukraine, because Russia is a party to that conflict. There's no legal definition of private military and security contractors, but this is an industry that's comprised of some very large and powerful companies. They perform military and security services, often but not exclusively in armed conflict, and often in support of controversial industries such as extractives. Some of these companies are more powerful than the states in which they operate, and they often fall through the cracks of corruption or merely through lack of jurisdiction under domestic law. In addition, large private military and security companies transcend international boundaries. They may be registered to do business in state A, have a presence in and recruit personnel from states B, C, and D, have contracts for operations in states E, F, et cetera. So you can easily see why the absence of international regulation often means impunity for war crimes and other violations of international law that are committed by operators in these companies. In my 6 years as a member of the UN Working Group on Mercenaries, and part of that time as chair of the working group, we worked pretty hard to promote new international legal regulation of both mercenaries and the PMSC industry. The target of this promotional work is the open-ended intergovernmental working group on private military and security companies that was established in 2010 by the Human Rights Council. The mandate and the objectives of this intergovernmental working group have been basically four things: developing a regulatory framework, examining existing standards, ensuring accountability, and all the while, through that process, engaging stakeholders. The work of the working group has been critical in addressing legal and ethical challenges posed by the ever-increasing reliance on private military and security companies, the uncertainty about the distinction between what is a mercenary and what is a private military contractor, and the development of an international framework for these services could help ensure that private military and security companies operate with greater transparency, with accountability, and with respect for human rights. So in the work that we were doing in the UN Mercenaries Working Group, we were focusing on a draft of potential international legal regulation that encompasses registration, recruitment, licensing, the scope of permissible activities for these companies, and most notably including a controversial question of whether or not they should be permitted to directly participate in hostilities and armed conflict, and also covering internal and external accountability mechanisms. But there's been a fair amount of opposition to regulation of this industry. Industry itself opposes mandatory regulation. There have been, I think, a fair amount of misunderstandings among diplomats, among lawmakers, about the existing regulatory landscape. For example, there is an international code of conduct and an international code of conduct association for private military and security contractors. But that's a voluntary mechanism. There's nothing mandatory about that. There's also a state-generated process, the Montreux document and the Montreux process. But again, that's not a regulatory mechanism. It is merely a statement by states of existing law concerning private military and security contractors, and in addition, a statement of what the drafters consider to be good practices. I should mention, though, and nobody's, I think, mentioned it so far, there is a new international treaty on mutual legal assistance, the Ljubljana Treaty. And to the extent that that is successful by virtue of how many states take it up, it could go a long way to filling a lot of the gaps of accountability that exist, particularly in the cases of entities like private military and security, like mercenary companies that transcend international boundaries, and by virtue of their power and their transcendence of international boundaries, often fall through jurisdictional gaps. I don't believe that reopening the Geneva Conventions is a wise exercise for this purpose, but I do believe there's a need for increased international legal regulation of mercenaries and PMSCs. Now, just briefly moving to the second topic, which is NIAC detention. There are no grounds and procedures listed in Common Article 3, which refers specifically to, non-international armed conflict, or in Additional Protocol 2. No listing of what are the grounds, what are the procedures that pertain to deprivation of liberty in non-international armed conflict. This is in stark contrast to the rest of the Geneva Convention's provisions dealing with international armed conflict, which have very detailed statements about what are the proper grounds for deprivation of liberty and what procedures have to be followed in order to accomplish that. Many authorities applying what we call a weak lex specialis doctrine assert that, well, you can't there's a conversation about whether or not it is permissible to fill the IHL gaps with human rights law. And some take the position that the doctrine of lex specialis, meaning that you apply the specialized law to the circumstance, not the general law, would have you come to the conclusion that, well, in armed conflict, you apply IHL, not human rights law. But that's the problem. That's where you end up with the gaps in coverage concerning grounds and procedures for detention. Other views of lex specialis are that, well, human rights law can and does apply in armed conflict. And I think that happens to be the majority of view of international jurisprudence, and that you do apply human rights law in those situations where the law of armed conflict is simply silent on the matter. So there's no conflict between the two regimes. But again, there's resistance to the notion that non-armed conflict rules in human rights law for deprivation of liberty and all of the due process bells and whistles that apply in accordance with human rights law are appropriate in armed conflict situations. So we have a lot of unanswered questions about not only what is the regime, but what are the particular rules and what is the source of rules for deprivation of liberty of individuals caught up in non-international armed conflict. I do believe that the reason the Geneva Conventions don't cover NIAC detention is because, 75 years ago, when they were thinking of non-international armed conflict, they were thinking primarily of internal armed conflict. You look at Common Article 3, and it speaks specifically of an armed conflict occurring on the territory of one of the parties to the armed conflict. They were not considering the kind of ubiquitous modern phenomenon that non-international armed conflict transcends international borders. So I think that's perhaps the reason why this coverage of grounds and procedures in non-international armed conflict is missing from the Geneva Conventions. But not only because non-international armed conflicts are now transnational, but also because so much of human rights law has blossomed since 1949, and so much of international law has shifted from mere concern about state-to-state relationships, which was the historical essence of international law, to now cover, and this is revolutionary in the last couple of generations, the rights and relationships between states and individuals. And I think this kind of shift in the landscape of international law also is entirely consistent with the notion that international law does have a place to regulate questions of grounds and procedures for detention in non-international armed conflict. So in conclusion, I'm going to say that I think new regulation, and again, I don't necessarily mean reopening the Geneva Conventions. I think there are other ways to do it, but it's necessary to regularize grounds and procedures consistent with international armed conflict and human rights law. Also, very importantly, there's no more reason why the ICRC shouldn't have mandated access to non-international armed conflict detainees as it has mandated access to international armed conflict detainees. And finally, on a more kind of U.S. domestic note, I think the Bush administration pretense that the designation of an individual as terrorist, unlawful combatant, unprivileged belligerent, somehow that removes someone from the protections of IHL that are otherwise provided to detainees in non-international armed conflict, I think that notion has to be put to bed. Thank you.
All right. Thank you, Gabor. We're going to now hear from Ezekiel.
Thank you very much. I was actually planning to start with a different theme, but the discussion about detention is quite interesting because it relates to the nature of non-state armed groups. And one of the reasons why there might be more rules, more elaborated for international conflicts is because states recognize themselves as equals, while having grounds and procedures in a treaty law for non-international conflict, when we recognize that all parties to non-international conflict have same obligations under international humanitarian law, would be also recognizing that non-state armed groups could potentially deprive individuals of their liberty and this would be regulated explicitly in treaty, international humanitarian law. It's quite interesting because the most majority of armed conflicts nowadays actually include non-state armed groups. So some of the numbers were shared before. But nowadays, the latest numbers say that we have 195 million people living under the control of non-state armed groups around the world. 64 million people live under exclusive control of non-state armed groups, and 131 under control that is contested or disputed. We have more than 400 non-state armed groups that cause humanitarian concern, around 100 non-international conflicts happening as we speak. So when we think about non-state armed groups, and again, this goes into a discussion of the tension, non-state armed groups actually create a tension in the international system because they are unlawful under domestic law. They are prosecuted because they take up arms against the state, but they have international obligations under international humanitarian law. So Common Article 3 explicitly contains obligations for states and non-state armed groups in the context of non-international conflict. And Additional Protocol 2 also, which has a more restricted scope of application than Common Article 3, contains treaty obligations for organized armed groups or dissident armed forces in the context of NIACs. And we know nowadays that also there are around 140 customary rules that are recognized to have a customary status that bind both states and non-state armed groups in non-international conflict. So in parallel of all these obligations, non-state armed groups are still unlawful entities under domestic law of the state. So the question of what non-state armed groups are allowed to do in non-international conflict when compared to what states are allowed to do in international conflict goes into the very core of the nature of the non-state armed groups, unlawful entities under domestic law, but entities that have international obligations under IHL. Now, this is what we have in terms of the this differentiated approach of these entities. The problem is, as I said, with the numbers that I mentioned, is that we have different types of non-state armed groups that are active around the world. We have armed groups that act as de facto authorities, that they have established state-like institutions, they have ministries, they provide services, they collect taxes in the territories they control, and we also have groups that have a very low level of organization, that they're dedicated to their military activities, and they don't provide services to the individuals living in the territories or the villages they control. So in this 450 non-state armed groups that we see nowadays, the question is, how does international law address these groups? And how does international law address the behaviors and the activities that they conduct? So traditionally, what we would see is that we have the international humanitarian law obligations, because when we were thinking about non-state armed groups, we were thinking about them from a military perspective. They are created, they're conceived to conduct war, either against another group or against a state. So if we see the definitions that have been provided by the international jurisprudence of what we understand as non-state armed group, is very much aligned with the military perspective. They have to have a certain hierarchy, they have to have command and control, they have to have military orders, they have to have someone speaking on behalf of that group. So very much in terms of what we see as a military, and this is what the International Criminal Tribunal for the former Yugoslavia had in mind when they put out the criteria that we need for a non-state armed group to exist under international humanitarian law. The problem is, as I said, we have 195 million people living under the control of these groups. And groups providing services, education, healthcare, collecting taxes, delivering birth certificates or death certificates. Many of these issues are not actually regulated by international humanitarian law. So if I go to Common Article 3, if I go to Additional Protocol 2, or if I go to customary law, there is nothing about collection of taxes, for instance. Or some issues might be regulated, but only if they have a nexus to the conflict. So the question is, what happens with issues that might not have a nexus to the conflict? So I'm saying this because in the last 30 years, the discussion has moved away from the international humanitarian law sphere to bring international human rights law to the possible application of this body of law to non-state armed groups. This is still discussed, but one of the reasons is because armed groups are acting in many places as rulers And because of this, there's millions of people living under their control. So it's like, what do we do with all these issues that are unregulated by international humanitarian law because they're not military in nature? So the discussion is now shifting towards including and bringing human rights law on board when thinking about non-state armed groups. And UN bodies have expressed themselves about this. We have statements by human rights experts from different either treaty bodies or special procedures in Geneva speaking in favor about the application of human rights law to non-state armed groups that exert de facto authority or control. So I'm just saying this because, again, it goes into this discussion of deprivation of liberty is what armed groups are allowed to do and what prerogatives, if any, they do have in armed conflict. Now, the challenges, and this goes into whether we need a new Geneva Convention to address the role of non-state armed groups, is why do we have this discussion? And when thinking about non-state armed groups, so there are two explanations. One could be either because there are issues that are not regulated, and this is where perhaps the discussions of human rights law were brought into the table, or because there is a lack of compliance of international law. So because many non-state armed groups may not be respecting the law, so there have been some initiatives to say, let's bring them to the table of negotiations because they didn't negotiate the Geneva Conventions. Some national liberation movements were part of the diplomatic conference that led to the additional protocols. But in terms of future lawmaking, some initiatives were put forward to say, let's bring non-state armed groups into the table because we need to include them for them to know the law, to know their future obligations, and therefore to be able to respect these obligations. Now, with that in mind, certain initiatives indeed were put in place. So I'm just going to mention three of them. So one is my former employer, and I should have said that I'm speaking on my personal capacity, but Geneva Call has, it's a humanitarian organization that has created what is called a deed of commitment. So they have 5 deeds of commitment that allow non-state armed groups to sign and commit to respect certain international law obligations. They go to the Alabama room in Geneva. More than 60 groups have come to the Alabama room in Geneva. They have signed these deeds of commitment to bind themselves to respect rules related to the ban of anti-personal mines, the protection of healthcare, the protection of children, the prohibition of starvation, and the prohibition of sexual violence and gender discrimination, with the goal of, again, increasing their level of compliance. So the idea is not perhaps to address the issues that are not regulated, but issues related to compliance and respect. There are 2 others. So one is the UN have been signing action plans with certain groups around the world on issues related to child protection. The Houthis, for instance, they have signed an action plan with the UN. The Syrian Democratic Forces in northeast Syria, they have signed an action plan with the UN dealing with issues on children and for instance, issues related to child recruitment and use that is also dealt with in international humanitarian law. And the last tool that I think it's quite relevant for the discussion is one that is explicitly mentioned in the Geneva Conventions, which is special agreements. So Common Article 3 encourages parties to non-international conflict to conclude special agreements to bring more international law obligations into the discussion and to apply more international law obligations. So some parties around the world, some groups around the world, they have signed special agreements with the territorial states to apply more IHL rules. And this is also explicitly envisaged in international conflicts. So not just in non-international conflicts, but in non-international conflicts, this is quite key because this allows, again, to bring rules that, for instance, would be applicable in international conflicts to non-international conflicts. So thinking about this issue of grounds and procedures for deprivation of liberty, this could be an avenue that perhaps, I'm not saying is easier because then you need to sit the parties to a conflict down and negotiate an agreement. Yes, not very easy. The last point I want to make is, and I know I'm running out of time, but it's an issue of how we analyze non-state armed groups' behaviors in a non-international conflict. Because there is always this perception that, they are responsible for violations of international humanitarian law. And I want to perhaps bring some nuance into a discussion that were also mentioned today in terms of whether IHL is always violated or always respected. And again, I mentioned there are very different non-state armed groups active around the world. It's very different to analyze the Taliban before August 2021 with the hundreds of my groups in the east of the DRC. Very different to think about the FARC in Colombia before they concluded a peace agreement in 2016 with the Islamic State in Syria and Iraq in 2015, 2016, 2017. So thinking about this, I just want to leave with two conclusions. The first one is non-state armed groups are dynamic entities. So it's not that they operate in the same way during the conflict they are living in. So at some point in time, they might decide to violate a specific rule of international humanitarian law. This might change over time because of different reasons. For instance, some armed groups that might be negotiating a peace agreement, they might decide to commit to respect to certain rules of international law. Groups that have certain goals, such as terrorize the civilian population, or they have an ethnic conflict, they are parties to an ethnic conflict, they might decide to deliberately target certain groups of the civilian population. That might change or not. I have been in touch with groups around the world that, for instance, when you talk to one of the commanders, that person has a specific view on a specific theme, that commander dies or is arrested, and then the new commander has a different view on the same theme. Humanitarian access, for instance. If you need to negotiate access into the civilian population, you have to renegotiate access with a new commander, just to give you an example. And that person may have a different perspective on what the needs of the civilian populations are. I think I ran out of time, but I'm just saying that let's bear that in mind, because when we think about compliance with the law by non-state armed groups, this idea of thinking of non-state armed groups as dynamic entities allows us to identify windows of opportunities. So when you work for a humanitarian organization, these are the windows of opportunities that you need to identify to engage the groups on issues related to respect of international humanitarian law. Yeah, thank you very much.
All right. Thank you, Ezekiel. Actually, I'll take prerogative here.
Yeah.
What was the second feature you were going to share with us
Second feature.
of the non-state armed groups?
I'm not
The
sure.
the dynamic aspect?
Yeah.
But there was another-
No, I was going to say that they have different, so dynamic aspect, and also that they have different perspectives with respect to specific rules of humanitarian law. So an armed group may have a perspective on targeting, and they might treat well people in detention, or they might decide not to use and recruit children in hostilities, and they deliberately target a group, a civilian population, because they belong to an ethnic group, or the other way around. They might torture detainees and not use or recruit children in hostilities, or, it's like, so it's different depending on the rule.
Okay.
Yeah,
Very
thank you.
good. Thank you. Thank you. Finally, we will hear from Amos.
20 years ago, when I first came here, Michael Scharf invited me to write an article about targeted killing. And that was my first publication after I retired from the IDF. And I was sitting here and listening to the speakers. I said to myself, wow, 20 years later, we're still talking about targeted killing in many ways. It is as if nothing has changed. Whether that's a good thing or a bad thing, I don't know. So I want to make a couple of things clear. I am an Israeli. I served for 20 years in the IDF. I live in Israel, but I don't represent anybody, and my thoughts are my thoughts alone. And I'm well aware, trust me, of the controversy out there, because as I say, we in Israel well understand the tensions, the conflicts, the controversies. I understand all that. For me, the question, and the reason I was so honored to accept Professor Scharf's invitation, is because this experts group has a unique opportunity, particularly post-October 7th, to address a critical question. And that is, who and what is a legitimate target? And what are the boundaries of articulating the legitimate target? And furthermore, what are the limits of collateral damage? And I think that with all the complexity of October the 7th, trust me, I get it. Where we are as Israelis, and I need to say one other thing, the politics of Israel, which also I'm well aware of, deeply involved in that. I want to leave that aside because it's not relevant to this conversation. But what is relevant to the conversation is, who are the legitimate targets? And how the hell do you go about defining a legitimate target in the immediate aftermath of October 7th, beginning 6:30 that morning? And how does that impact the question of collateral damage? And I repeat, Michael, there's a great opportunity here with the experts' report to address this, as complicated as it is, and trust me, I get it. I need to add two other things. As an Israeli, for me, all roads lead through the hostages. That is where it begins and where it ends. And then the question is, in the context of legitimate target and collateral damage, what is legitimate in the context of trying to save the hostages, with the understanding that, again, it's all obvious out there, that saving the hostages is a double-edged sword. Soldiers have been killed trying to save hostages. Hostages have been murdered while they were being rescued, hopefully. And obviously, the Gazans are also being killed while the IDF is trying to rescue the hostages. In the immediate aftermath of October 7th, the following decision was made. Controversial, I know. That all members of Hamas, we could have a long conversation about what the hell that term means also. But all members of Hamas who participated in the planning, I hate the word, translating from Hebrew, the execution, wrong word, I know, of October 7th were defined by the IDF as legitimate targets. That obviously is problematic as problematic can be. On the other hand, hang on, October 7th is a massacre. You don't have to be a genius to know this. Go watch it on YouTube. What happened to the 1,500 Israelis at the music festival is a full-fledged massacre. No more and no less. And then now you have the hostages who have been brought to Gaza, and you have now the following categories. Category number one are the members of Hamas who planned the massacre, who crossed into Israel and brutalized and murdered Israelis at the Rock Festival, Israelis in the towns around this, what's called the Gaza envelope, and then into the towns in Israel. That's group number one. Group number two are those then who received the hostages. And I invite you all to go to YouTube. Maybe that's uncomfortable, but it is what it is. The Gazan population embraced those who brought back the hostages and jeered, sneered, and assaulted the hostages who were wounded themselves. That also needs to be stated. Are they legitimate targets? We viewed them, yes, as legitimate targets. Is that problematic? Sure it is. On the other hand, so is raping and sexually assaulting women problematic as hell. It doesn't happen in a vacuum. And then the third category that I don't know the answer to this, but it's out there, we need to be honest with ourselves. Israelis who are being held hostage are being held in apartments, some of them in apartments, some of them in hospitals, and obviously those in tunnels. So if you're seeking to do the following, one, to rescue the hostages, and two, to quote unquote exact a price on Hamas, which was responsible for October the 7th, is there going to be collateral damage? The answer is yes. And I confess, as Michael knows, I've been involved in this stuff for years. The hell if I know what is the limits of legitimate target killing and the limits of legitimate collateral damage. But that's an issue that, again, not to repeat, there's an extraordinary opportunity to address this question. We have said, and again, I get the controversy, believe me, that anybody responsible for October 7th, legitimate target. And when we use the phrase, translate, I don't know how many of you, if anybody here speaks Hebrew, sikul memukad is what we call targeted killing. But the problem is the following, the long list of problems is the following. One, that some of those who are being killed by the Hamas members are surrounding themselves with Gazans. Are all those Gazans guilty? No, of course not. Are some of them innocent? Of course they're innocent. They are human shielding. And trust me, I understand human shielding. I get it, trust me. But the truth also needs to be said that X percentage of the people killed who are being human shielded are being human shielded by Hamas. How do you then say you can kill this particular guy, but you can't kill him because he's being human shielded? I don't know the answer to that. And we now know that in November of last year, November or December, 3 of the hostages were killed by the IDF because they were human shielded by Hamas, who had human shielded them. In addition to that, Israel we've also killed at least 3 hostages, not in addition to those 3, in a case of my mistaken identity. Happens. But for me, participating in this, we need to really ask ourselves, what are the limits of the definition of what's a legitimate target? And when we've created 3 different categories, I know it's controversial. One, those who did October 7th. I personally have no problem with that. You did October 7th, you're responsible. Two, the population that received the hostage, and go to YouTube and watch it. We have defined them also as legitimate targets. Is that problematic? You betcha. On the other hand, going into Israel and enabling the killing or the participation in the killing without support of the population is an issue that also needs to be addressed. And this third category, and hell if I know the answer, but it's something that we absolutely must discuss, are those who took into their homes the hostages and are, holding hostages. Now, some of you will tell me, well, maybe they were forced by Hamas at gunpoint to take them into their houses. Don't know the answer to that. But those are exactly the kinds of questions that need to be addressed. With respect to the collateral damage, I know international law doesn't articulate numerically this, tuck, tuck, tuck. There is no doubt, and I think we're all clear about this, that the Gazan population is clearly paying a price for this on a day in, day out basis. Full stop. But so are we. I mean, that also needs to be stated. So I think in many ways, October 7th, which is a horror show to end all horror shows, there are no words for October the 7th, has raised really powerful questions that we need to address. Complicating it all, and I don't want to get into this, is the reality of Israeli politics, which I could write a book about it, don't want to write a book about it, because what we have done, we, as Prime Minister Netanyahu, and by the way, I think Michael knows, I'm on public record of what I think about Netanyahu, it's a different conversation, has said victory at all costs, nitzachon, victory. I confess, at the age of 67, I have no idea what the word victory means in something that will not result in victory for anybody. We're all losers here. And this notion of defeating Hamas, it's not going to happen. I come from the school of thought, having been involved in operational counterterrorism for 20 years of my life. You cannot defeat an idea. You cannot defeat Hamas. It's a fantasy out there. Now we're talking about Hezbollah, but I don't want to talk about Hezbollah because that's a different conference, right? Michael can invite me back to talk about Hezbollah. So where I leave all of you with is the following. One, this is, in a really shitty way, a unique opportunity to have the kind of discussions that your experts conference, Michael, has this unique opportunity to make a significant contribution. That's one. Two, I think the international community, and I don't want to offend anybody in this room, but I will a little bit. The international community has abandoned the hostages. With all due respect to the ICRC, we in Israel are waiting for you all to get involved in this. And three, there is a really important opportunity in terms of international law to get out of here and to move the ball forward and to address the issues that absolutely must be addressed. Thank you.
Okay, thank you. We're now going to allow each of our panelists to pose a question, either to the group or to another panelist, and we'll allow Ezekiel to start first.
Okay. No, thank you very much. I have written down a few points. Let me go through this. For me, it's a general question to all of you, because I was thinking when I was listening to your intervention is whether we would have these same discussions if IHL was fully respected. So if IHL was fully respected, would we be sitting here discussing about whether we need to open up to new lawmaking or what we have is enough?
So I'll at least start on that one.
Yeah.
I mean, I think the question of IHL being fully respected depends on what your perspective of what the law is. If you fall in the category of thinking human rights law is picked up and fills all the gaps, then I think there would be disagreement as to whether that's a viable outcome. So does that mean that if you are those who receive the hostages in category 2, they're not legitimate targets, they're actually under human rights law, they should just be arrested. So they have to be arrested, and you can't get Hamas to arrest them because there's no Israeli positive control over the territory. So who's going to arrest them? And if they are arrested, then are they even legitimate individuals to detain because they have to still be in a category of being an enemy, right? So human rights law doesn't answer that question. All human rights law tells you in that case is that you need to arrest him and treat him as a civilian. And I don't think the institutions are capable of doing that. So I think it comes back to this point that there is a gap in the law in this area, and it's for all the reasons we've just heard, whether it's because these horrific abuses are coming because there is not clarity in what to do with them, to your very valid points about whether or not you just bring in these groups on a case-by-case basis to agree to a greater panoply of rights. I think it's because there aren't enough laws there. So I don't think it's the lack of respect. I think there isn't a clear enough guideline or template for what the rules are to then apply it.
Others?
So my answer to that question is yes. I do think we would be having this panel. Well, first of all, I mean, if Lou Henkin were still alive, I'd be curious whether he would still say that most states obey most international law most of the time, Jennifer, as you related to. But even if he would still agree with that statement, that does not account for non-state actors. And I think if anything, what this panel has shown is that aside from the question of compliance with established rules, there's a lot that can be done and that has to be done to extend and clarify law in keeping with the notion that while at the time of the convention's drafting in 1949, the parties had a pretty bright line distinction between the need to regulate international armed conflict and the need to leave non-international armed conflict to the prerogatives of states and their sovereign authority. That just isn't true anymore. And one of the great reasons why that's not true anymore is that so much has happened since 1949 under the rubric of international human rights. And a lot of what has happened in connection with the development of international human rights also sees reflection in the ways in which IHL has been interpreted. And again, I'm speaking about the growth of international legal regulation from what was traditionally state-to-state relationships now to the rights of individuals and the responsibilities of states vis-a-vis individuals. And deprivation of liberty is a good example of that. And I think it shows that even if both states and non-states were complying with a consensus of what IHL requires, these gaps would still exist. And so I think, yes, we would still be here.
Finally, Amos, do you want to respond? No? Okay. Gabor, your question now.
My question is, I want to cede my prerogative to respond to the ICRC. And I'm particularly curious in response to your observation, Amos, about the ICRC's role in connection with hostages. I know there's been a lot of complaint about the ICRC as not being attentive to the hostages. But I also know that, on the other hand, Hamas has not been, shall we say, welcoming to the ICRC to visit hostages. Likewise, Israel doesn't open its detention facilities to the ICRC, so there is at least some symmetry there. But I do wonder whether or not, from the ICRC's perspective, their role in connection with the plight of the hostages is purely in the hands of the parties to the armed conflict, or is there something that the ICRC, hasn't been doing that it should be doing?
You want to come to the mic?
I'm calling you out, Jonathan.
No, I appreciate that. And wonderful discussion, wonderful panel, and really want to hear it continue. I do want to say the ICRC has and continues to condemn the horrific acts of October 7th, right? We have also called for the unconditional release of the hostages. and we've also called out with concern other acts with regard to the hostilities. In terms of our public statement, and I'll just end it here, I just refer people to our public statements, and I'd also say, outside of this panel, once I leave the microphone, the delegation here is happy to talk to anyone offline to discuss the matter further. But I appreciate the opportunity to discuss the issue, and again, a wonderful panel, and looking forward to hearing the rest of it. Thank you.
Thank you. Amos, do you want to pose a question to the group?
So obviously the question to my distinguished panelists is, given October 7th has presented in a really, really shitty way, pardon my English, an extraordinary opportunity for a group like this to address critical issues. And I go back to your comments, and your comments. Moving ahead, I mean, when this will be over, whatever that means. If you were a queen for the day, if you were a king for the day, and if you were a king for the day, what would you do in terms of everything we've discussed with respect to international law? International law to where? In 30 seconds.
Looking at me, so in 30 seconds, I mean,
And then you 30
yeah,
seconds.
I would absolutely take the opportunity and try to get some concrete law in some of these areas that we talked about. I mean, I like the way several of my panelists have couched it, so I'm taking a lot of good notes up here. But I think you absolutely have to lay out a framework for, targeting individuals, who they are, the status of people that are not a POW and are not a civilian in an occupied territory. There is clearly, and I do not believe that human rights law can fill that gap. So if I were queen for a day, I would help get that drafted together. I would have the ICRC on board. We would have organizations all around the world say that it's brilliant and it's awesome, and they would love to have a special agreement to be part of it, whether or not that's viable. But I liked your idea of sort of engaging in some way the non-state actor community, even though that gives a legitimacy that we oftentimes don't want to afford.
30 seconds. 30 seconds.
I'm just going to agree with that.
That's easy.
Yeah, because the traditional notion that there's only two flavors, combatant and civilian, and
Right.
and the presumption is of civilian status in case of uncertainty, according to IHL, according to the ICRC, contested by the United States. But anyway, it's just overly simplistic, and I think there needs to be some more nuance brought to the question of the status of individuals that are caught up in and participate in armed conflict. Again, this is so Geneva Convention based that it's difficult to say, well, let's not open up the Geneva Conventions to do that. I mean, you can deal with mercenaries and private military contractors with a separate instrument, but on this, I find it more difficult to maintain the position that this needs to change, but let's not open up the Geneva Conventions to do it. And so I'm not sure what the appropriate mode or mechanism is to accomplish that. But I'm just in agreement that that needs to be addressed.
Absolutely.
I am in partial agreement, I have to say. Because I think the challenge here is to understand the root causes of the violation. And I think the point of the training and clarifying the law, it is important, but it's not enough. In many places, and again, I'm speaking in my personal capacity here, but in many places, the problem is not what the law says or what the law doesn't say. There are other reasons why parties behave in certain ways. So again, October 7th was not because, the law wasn't clear. There were other root causes of those violations. And then what happened after October 7th with, again, violations is not because the law is unclear, it's because there might be other reasons. So what I'm saying is, I think we need to understand the root causes of violations, but also understanding the root causes of compliance. And this is why I tried to bring into the discussion before, saying like, parties who are in conflict, sometimes they do comply with international law. So understanding why they comply with international law might help to address the violations of international law in armed conflict. Again, training or lack of knowledge could be one of them, but in certain places, parties don't respect the law because of other reasons. They might have a different interpretation. And then the problem is not whether they don't know what IHL says, but how they understand the notion of civilian. If you talk to the Taliban, and they were very vocal on this about their notion of civilian, they say, we can only attack military targets. It's because they thought like certain groups of individuals that we would consider to be civilians, for them, they were military targets. but the distinction was not between, people who can be targeted and people, it's more nuanced than that. So again, I think training, it is important, and clarifying the legal notions is important, but then other steps need to be taken. Yeah.
Great. Thank you. Finally, Sandy, a question for the group?
Yeah, I mean, I have so many, so I'll come back with one that wasn't, maybe one that was specifically addressed and one that wasn't specifically addressed. So, and I'll defer, I think, to my Israeli colleague to answer a little bit. So I like the way you said sort of like, what are the limits of collateral damage, right? Because we always look at it as proportionality is the cornerstone of the Geneva Conventions, and yet you clearly can target, it's the war criminal is the Hamas agent who's using human shields. And so when the war crime is committed on the other side, and that poses an impossibility, right? An impossibility to target and therefore move along the process of the conflict, it necessarily prolongs it, which has other civilian deaths. So I like that idea, and I'd like to hear from you more on it, as well as one other topic, which is this notion of sort of the jus ad bellum to start with. So we have the October 7th attack, and so there is a legitimacy in the self-defense, and yet the entire world community is calling for a ceasefire, which takes away, it almost undermines the legitimacy to act, as though this isn't really as legitimate of a conflict. That doesn't mean you'd always have calls for peace, but is something about the call for a ceasefire because there are so many civilians being killed, is that taking away any of the jus ad bellum in this type of conflict?
Me?
Yeah, sure. Or anyone.
So Israelis like me, who demonstrate every Saturday night against the present government, we call for a ceasefire. And the reason that we call for a ceasefire is because from our perspective, it's the way to most effectively, hopefully, result in a release of the hostages. When I said earlier that for me, like the hundreds of thousands of others who are demonstrating every Saturday night, all roads run through the hostages. And I'm also well aware of the fact that there are, if you brought, Michael, other Israelis, 2 Israelis, 3 opinions. There are clearly at least 3 opinions. Their X percentage of Israelis were divided. 2/3 of us want a ceasefire for a hostage release, and 1/3 of us are against the hostage release because we view that as, those who are opposed to it, because they view that as surrender, whatever the hell that word means, to Hamas. That also needs to be stated. But for people like me, and I speak only for myself, the purpose of a ceasefire, it would be hopefully to have a prisoner release and a hostage release. And once you do the hostage release, then and only then can you begin the process of figuring out what we call in Hebrew the day after. Because until the hostages are released, until there's a ceasefire, we can't have the day after, which is also a question, I think, for international law and the international community. What the hell does the day after in Gaza mean? And Michael, I see your students are here. Here's a great other law review article for all of them. What does the day after mean in the present conflict? Both in the context of international law, international community, global community. These are enormous questions, and I know this sounds really bad. October 7th really presents all of us here an extraordinary opportunity to ask ourselves, Geneva Convention, yes, but Geneva Convention to where? An international community to where? That clearly needs to be stated. The ceasefire, I support it because for me, the single most important issue on the table is to have the 101 hostages come home. How many of them are still alive? A different question. But they need to come home, and only then can we begin somehow asking ourselves, what's next?
Would anyone else want to respond to that? No?
So, yes, please. On the jus ad bellum, the relationship of the jus ad bellum issue to the conflict, and this is an academic point, application of jus ad bellum presumes the existence of 2 states. We don't talk about jus ad bellum when it's state use of force against a non-state actor, and there are some controversies remaining about whether or not this is an interstate use of force, so that kind of leaves open the question of whether or not UN Charter aspects of the right to use force in self-defense are even in operation, which is not to question whether or not Israel has the right to use force. It's just to question whether or not the jus ad bellum framework, the UN Charter, is the proper mode of analysis. Then also just on the question of the hostages and human shields in particular. I know that over time there has been some attraction to the notion that the targetability of people acting as human shields could be determined on the basis of whether there's evidence, whether they're doing so voluntarily or involuntarily. And that, I think, is a pretty dirty road to go down because of how difficult it is to determine the question of voluntariness in a situation as fraught as the one in which people are either compelled explicitly or compelled implicitly to act as human shields. So that's just kind of a word of warning about the human shield issue.
Ezekiel, you want to say?
Point.
No. Yeah. I guess, so I would just ask a question, and maybe it's primarily for Amos, but also for others. So, I mean, from the Palestinian perspective, right, with the tens of thousands of lives that have been taken, I guess the question is, legitimate targeting gets you, I guess, only so far in terms of deciding who are the legitimate targets. And so raising the collateral damage issue, I mean, I think we are then still falling onto questions of proportionality and distinction and precautionary measures. And I think there are certainly those who would call into question how the Israeli military is exercising and adhering to those criteria. And I guess I wonder what you would say to that.
So when I say that's a good question, that means I don't really have a good answer. I think that, so I want to draw on my own experience, if I may. So in full candor, I think, as some of you know, I was involved in targeted killing while serving in the IDF. Well, because I served as the legal advisor to the Gaza Strip from 94 to 97. And again, I've written about it and I'm very open about this. Post October 7th, I say this with air quotes, and it's problematic, I know. In some sense, the rules have changed. Because when I was involved in it, we were focusing on the specific individual who we defined as posing an imminent threat to Israeli national security, full stop. And I think both beginning that morning and where are we almost a year later, right? Next week is a year, right? The legitimate target definition has been expanded. Can I give you clear swim lanes? The answer is no. And you divide into three distinct categories. Category number one is the efforts made to kill Hamas leadership, whether it's Mohammed Def or Sinwar or the others. Mohammed Def, I can tell you, when I served as legal advisor at Gaza Strip, every goddamn week I would hear, this week is Mohammed Def's last week. And, it took us a while, but finally, he's no longer with us. Sinwar was in Israeli jail. The head of Hamas, we had him. And we released him in the trade for the Israeli soldier for Gilad Shalit. He's a total psychopath, 100% psychopath. Now, when you try to kill him, he surrounds himself with people. Are they collateral damage? Yes. Is that legitimate? It's a long, complicated question. The whole notion of Hamas leadership, that's one. Two are those who were involved in October 7th. And I think by now, I don't know if we've killed all of them, we've killed many of them. Did some of them surround themselves with people? Yeah, of course they did, because that's just the way it is. That's collateral damage. Is that legitimate collateral damage? Michael, there's another law review article for your students in the back. And the third, and I'm repeating what Gabor's point is excellent. The families who turned their apartments over to have the hostages in their homes, the hospital directors who turned their hospitals over to have the hostages in their homes, the hospital directors who allowed surgery without anesthesia, allowed amputations without anesthesia. What's that? Are they legitimate targets? I don't know, but I think those are problematic as hell. There are no clear answers here. I think the beauty of this gathering is at least the opportunity, I thank you, Michael, for inviting me, at least to have this no bullshit conversation, because it's the only way I know how to have this. These are seriously difficult questions. no sugarcoating allowed here. This is hard stuff. But there is an opportunity when this ends to begin the process of asking ourselves, how do we proceed forward after we finish with this, whatever that means.
Okay. Thank you. We're going to, I think we actually have to finish up now, I guess. I apologize. Certainly there will be time to engage with our panelists afterward and throughout today. I want to thank our panelists for your really insightful comments and your passion and care about these challenging issues. So thank you. We have